Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled Texas Court of Appeals Memorandum Opinion. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, I would like for you all to hit that like button. And also, if you're new to my channel, hit that subscribe button. And also, hit that notification bell and make sure you put that you want all notifications so you all can be notified when I'm dropping these powerful videos. So without further ado, let's get to it. Okay, so for all those who have been following me for quite some time, you all know that I've been keeping y'all up to date with this Court of Appeals case, okay? We already beat them once in the appeals court, and we basically beat them twice again this time. So now they're trying to remand it back down to the lower court. But nine times out of 10, after I go back over the case and read through certain things, we may file a petition for review in this matter with the Court of Appeals because they have a few things that I don't like that pretty much seems off to me. So I'm gonna go back over the case again, and if I find anything that needs to be addressed in the appeal that I would like the trial court to, I mean, that I would like the appeals court to address and even reverse, we will file a petition for review with the Court of Appeals. Okay. So now let's go over the appeals court opinion. It reads, very top, guys. It states what? Affirm in part, reverse and remand in part, and opinion filed February the blank 2025, which is what? This month, this year. Let's continue on. As you all can see, we in the what? In the Court of Appeals, 5th District of Texas at Dallas. The appeals court case number I crossed out, and it states what? In the interest of a minor child, the minor child name I crossed out. The trial court cause number I also crossed out. Highlighted in orange, it states what? Memorandum opinion. Let's read it. It states, before Justice Breed Love, well, we ain't got to read the justices. You all can read the justices' names. Let's pick it up at the top. It reads, the trial court signed an order under Uniform Interstate Family Support Act on March blank 2024, ordering appellant, who is my aunt, Mr. Santana, to pay monthly child support to his child's mom, whose name I crossed out, for the support of the minor child's name, who I crossed out. Then it states, in two issues, Santana contends that the trial court erred because one, the trial court did not establish personal jurisdiction over him, and two, the trial court abused its discretion by entering an order under the Uniform Interstate Family Support Act without establishing Santana's paternity. We conclude that the trial court properly exercised jurisdiction over Santana, but as conceded by appellee, the Office of the Texas Attorney General, the OAG, there was no evidence introduced to support the findings. So this page one, guys. Now let's go to page two. Let's go there. Okay, so now we have page two. Let's continue on. Of a legal duty of support between Santana and the minor child. So again, guys, you all can see that basically they affirm that the trial court had jurisdiction, but they reversed that there was no legal duty of support between Ma'ak and the minor child. But let's continue on. It states, accordingly, we affirm the trial court March 19, 2024 order in part and reverse in part. We remand the case to the trial court for further proceedings. So now they want to send the case back down to the trial court to try to establish paternity, which we got something for that as well. But I think before it gets back down to the lower court, 9 times out of 10, after I go back over everything, we probably file a petition for review in order to get them to straighten out this jurisdictional part because I believe they made a few mistakes on that as well. But let's continue on. Number one is what? Personal jurisdiction. Let's continue. In his first issue, Santana contends he was not served with citation under Civil Rules of Procedure 106 or with notice of a hearing under Civil Procedure Rule 21B. He contends that he filed a blank under Rule blank and the OAG failed to show cause in strict compliance with the rules of civil procedures. Then he states, citing Wilson versus Dunn. But let's continue on. It states, he argues that actual notice without proper services is sufficient to establish jurisdiction. He also contends that actual knowledge of the lawsuit is insufficient, arguing that there are no presumptions of a valid issuance, service, or return citation when examining a judgment. And cited the case law, which is primate construction, but let's continue on. Then it states, for well over a century, this court has required that strict compliance with the rules of service of citations affirmatively appear on the record in order for a default judgment to withstand a direct attack. the record reflects the following events relevant to Santana's jurisdictional challenges. So they're basically trying to say this is the events that have transpired uh, that they want to go back over to try to justify that they established jurisdictional Mr. Santana. But let's continue on. It states one, the OAG filed a Uniform Interstate Family Support Act petition on August the 25th, 2020. Then it states pleading that the trial court has jurisdiction over Santana under Chapter 159 of the Texas Family Code. In its position, the OAG requests service of process on Santana. So as you all can see, this is page 2. So now let's go to page 3 because they so far claim that they have what? Service of process over Mr. Santana. But let's continue on. Okay, we're on page 3. Number 2, it states the record includes a return of service made under penalty of perjury, showing service by personal delivery on Santana at his address in Dallas on October 16th, 2020. Okay, so another thing about this case, guys, my Aunt Santana, he went to someone else on YouTube before contacting me. So all this 2020 stuff has transpired before me. Okay, but let's continue on. So let's go to number 3. It states Santana responded by pro se pleading on November 4th, 2020. Although he pleaded that the court lacked personal jurisdiction over the undersigned, the basis of this argument was not deficient service of process or lack of notice, but rather his lack of consent to be bound by statutes and codes. Then it states, highlighted in yellow, Santana did not otherwise answer the lawsuit. Number 4, the trial court signed an order under the Uniform Interstate Family Support Act on November 12, 2020, finding Santana to be the father of the minor child whose name I crossed out. In green, it states what? And ordering him to pay child support. On March 22nd, 2022, now this is when we got in contact with each other back in 2022. So it states what? On March 8th, 2022, Santana filed a motion to set aside the default judgment and to terminate his child support obligation. He also filed a blank and set his motion for a hearing by Zoom. Santana obtained a citation directed to Mr. Woods, who is the what? Who is the attorney who signed the OAG's pleading on behalf of the OAG. The OAG filed a verified original answer and included a general denial, pleas of sovereign immunity, and a request for attorney fees or other monetary relief. On November 3rd, 2023, Santana filed a blank, claiming that the OAG and the state of Texas collectively owe him in excess of $100,000. He requested that he may take all necessary steps to secure his claim to the debt owed to him and to collect. So as you all can see, we was applying pressure between 2022 and 2023, but let's continue. It states, we concluded the trial court had jurisdiction over Santana. Then it states, the record reflects that he was personally served with the OAG's lawsuit on October 16th, 2020. Again, guys, anything back on 2020 was before me. We started working back in 2022 till now, but let's continue on. Case law to support that, but let's continue on. Then it states further, highlighted in yellow, Santana for affirmative relief Santana sought affirmative relief from the trial court. By doing so, he made a general appearance and waived his special appearance, which is not true, guys. Okay, that's what I know. That part is not true. But let's continue. Then it states, party enters general appearance and waives special appearance when it seeks affirmative action. That's not true, guys. Okay. That's if you it's only true if you miss certain steps. So I don't know if they're talking about before 2020, I mean 2022, or after 2022, because the last thing they quoted was a lawsuit on October 16, 2022. But I don't mean 2020. I don't know if they're talking about during that time or during the time we was working together. That's what I'm confused about. So now let's go to page 4. Let's see if they go into more detail. But let's go to page 4. Okay, so we on page 4. Let's pick this up at the very top where it's highlighted in yellow. And it reads, inconsistent with an assertion that the trial court lacks jurisdiction. So they trying to say that my argument was inconsistent, stating that the trial court lacked jurisdiction because they are claiming, which is the OAG, is claiming that they served him at his address. And when he went to challenge it, by him challenging and asking the court for relief, he also waived his jurisdictional challenges, which is simply not true, okay? If you're asking the court for relief based off of jurisdiction, then you're still maintaining your right to challenge jurisdiction. So you do not waive your jurisdictional challenges by petitioning the court for the to vacate the order for lack of jurisdiction. No, you maintain that jurisdictional argument because once the court decides that they lack jurisdiction, then they cannot proceed forward. That was basically stated in the original order granting the bill of review that we filed into the Court of Appeals, that the Court of Appeals granted last year. So both orders are basically inconsistent with each other. So I'm trying to get better clarity or understanding of what this order is basically trying to state. But let's pick it up with it's highlighted in red, very top. It says, we overrule Santana first issue. So they basically overrule and states that they do have jurisdiction over him. So now let's go to point number 2, which is the child support order. Then it states, by letter of July 24th, 2024, the OAG has made a partial concession. Remember, guys, I went over that letter when my aunt got it back in 2024. Go back to the last Texas Court of Appeals video update, and you'll see that we went over that letter. But let's read it. Let's continue on. It states the OAG concedes error on one part of this appeal, highlighted in green, guys. Insufficient evidence to support the rendition of an order affecting the parent-child relationship and a child support obligation. Acknowledging that the mother general testimony about Santana parentage of the minor child was not introduced into evidence. So again, they basically saying that the OAG concedes on appeals because the mother did not provide, or they did not introduce the mother's testimony into evidence, claiming that he is the father of the minor child. Okay, even though the mother was claiming that the whole time, which doesn't make any sense at all. Basically, they can't prove that he's the father of the child, so they're trying to say that because they can't prove that he's the father of the child, they're going to use the mother's general testimony as an excuse to get out of that fact that they can't prove that he's the father of the child. But let's continue on. It states the OAG concludes, based on the foregoing, the OAG concedes error as the face of the record demonstrates that there was no evidence introduced to support the finding of a legal duty of support between appellant and the child of suit. Accordingly, we sustain Santana's second issue. So again, guys, because they could not prove that, they sustained the second issue. So that means what? The original order of support, again, that they tried to place on him the second time, is also overturned and dismissed. Then it states conclusion. Let's read it. Conclusion. We affirm the portion of the trial court March 19, 2024 order ruling that the trial court had jurisdiction over Santana and the subject matter of suit. We reverse the portion of the order regarding Santana parentage and duty of support. We remand this case to the trial court for further proceeding. So they want to bring it back now. Now they're trying to bring it back down to the trial court for further proceeding to try to establish paternity, the same paternity that they couldn't establish the first time. So again, we're going, if they try to bring them back again, we're going to apply pressure. But even before they try to bring them back, we may do a petition for review. Okay. But there's one more page. Let's go to the next page. I think that should be the last and final page. Let's go to the last page and let's read what it states on the last page. Let's go there. Okay, as you all can see, this is the last and final page titled Judgment. Again, the minor child name are crossed out. The appeals court and trial court case numbers are crossed out. Let's continue reading. It states, in accordance with this court's opinion of this date, the trial court's March 19th, 2024 order under Uniform Interstate Family Support Act is affirmed in part and reversed in part. We affirm the portion of the order ruling that the trial court has jurisdiction over the appellant Santana and the subject matter of this suit. We reverse the order's provision regarding appellant Santana's parentage and duty of support. We remand this cause to the trial court for further proceedings consistent with this opinion. It is ordered that each party bear its own cause of this appeal. Judgment entered on the blank day of February 2025. So again, guys, this year. But as you all can see, they just affirmed that they have jurisdiction of the over the appellant and the subject matter, but they reversed the order regarding the parent-child relationship and the duty of support. So basically, there is no order of support. They want to bring it back down to the clerk of. They want to bring it back down to the family court, which is the trial court, to try to see if they can try to establish paternity, the same paternity that they couldn't establish the first time in the lower court. So again, guys, I'm the only channel showing y'all up to date live cases as they are going on. Okay, separating the real from the fake. You all know what's real and what's not. You all can see what's real and what's not. We're going to continue to apply pressure. I'd like to thank you all for continuing to rock with me, support me, and just, showing your love and, requesting these videos. I'm going to be doing more videos, more testimonies coming real soon in the near future. We're going to continue to apply that pressure. Again, I would like for you all to hit that like button, share my videos for me to get more people to get understanding of what's going on so they can, get my information out there because as you all know, YouTube has been shadow banning me for years now because they don't want this information out there. But again, we're going to continue to apply pressure. But that's what I'm going to do for today. If you all need my help, Hit me up in my email at y'allismagnified@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. Again, guys, the only channel showing y'all this live cases as we go on. With that being said, you all be blessed, and I say shalom.